that's been
Right.
happening.
Yeah,
So
that's good.
Yeah.
All right, so let's get started, guys. We've had a nice chat.
Oh yeah.
All those people who joined early, welcome, welcome. You've sat here and listened to us chat. So I'm Angela, for anybody who doesn't know me, and I am Family Court Corner. We have Joanna Shaw and Rose Pellar from JMS Law, and they are our two expert lawyers today. I just want to tell everybody that this is nothing we talk about today is legal advice. It's all for general informational purposes. So with that in mind, some of the questions that were submitted were sort of asking for specific legal advice based on situations. So we're gonna go through the night tonight and answer as many as we can along the way. I'm gonna sort of work questions into our discussion today. And yeah, how does that sound? Great? Good.
That's great.
So I don't know if you guys want to introduce yourself quickly. I know there are some new people here that didn't attend the last one. So Joanna, do you want to just give a quick rundown of who you are and what you do?
Sure. So my name is Joanna, and I am the founder of JMS Law, one of the principal lawyers there. I am an accredited family mediator and also a children's lawyer, and have also the creator of a parenting program that helps parents who are in conflict and in the court process to find better tools to communicate effectively. So that's me.
Thank you, Rose.
Yeah. So I'm Rose Pellar, and I am an associate lawyer with JMS Law. I practice family law. I also do life change coach programs, helping women through divorce. I also practice wills and estates. And in my world, what I would love to see is that everyone who goes through divorce will end up in a better place.
Thank you, Rose. Okay, so tonight we are talking about, I think we're going to talk about a lot, but let's focus now on settling versus litigating. I think it's a good thing. We were going to talk about it last webinar. We sort of ran out of time, and I think it's a bigger topic. So we've made it its own webinar tonight. So I think the first question, it might be a huge question, but I'll leave it with you guys. I don't know if Joanna, you want to answer this, or Rose, but how do you determine if parents should mediate or litigate?
I don't know, Rose, do you want to start with that?
Okay. Typically, from our standpoint as being lawyers, and we have our first initial consultation, we're getting the story from our clients, and we get a sense of how agreeable or cooperative they are as parents and as individuals. And typically, my bias is towards negotiations and settlement. In fact, I do not go to court. I believe that the individuals have hard-earned money that they don't want to give away all to lawyers. And so if I can help them do that, I do that. So I get a feel for how far apart they are in terms of parenting decisions, time they want to spend with their children, just in general. How are they as parents? Are they agreeable? Will they be able to cooperate, or with some negotiations come to a settlement? If it's apparent that it's a complete conflict and they're always arguing, at least from the standpoint of the client I'm seeing, and if it's really that far apart, I might suggest litigation, but typically I do offer them the option of going to mediation, because with a mediator, they're in front of one person who can hear both sides at the same time. Whereas if they're just going through lawyers, I'm only hearing one side, and the other party's side may be quite contradicting to what my client is telling me. So having a mediator may make the process a lot simpler because that person is getting both sides at the same time. So I would not immediately send someone to court to argue custody or parenting time or access, that kind of thing, if I feel that with the help of an objective individual, they can come to some settlement in the middle somewhere. So what do I usually recommend? If they are cooperative right off the bat, and just through negotiations, they can come to some agreement, then I would just simply say, we can negotiate this. But if I find there's some difference that will make a difference, the next step I suggest is mediation. I don't send them immediately to court. In fact, if it can be avoided, that would be ideal. Mm-hmm. The children don't need to be dragged through this process. That it doesn't really set the proper climate for parenting.
So some of the struggles that I see and hear a lot from parents are, they go to mediation with high hopes, and they reach some agreements. So you get that, I forget what it's called, a memorandum of understanding or something, right? Where the mediator writes it up and then you go back to your lawyers and everybody signs it. And there are many times where the other parent changes their mind after mediation. What happens then?
So if I could sort of answer a little about that as a mediator and perhaps even as a lawyer. So Rose and I are both from the same firm, and Rose and I are very resolution focused. Our entire firm is very resolution focused. And this is one of the reasons why Rose is saying, if we cannot negotiate, then we would like for people to potentially start with mediation first, and then maybe we can negotiate things that are difficult. So your question, Angela, around, okay, so if we go to mediation, we agree, the mediator writes a report, memorandum of understanding, some kind of a preliminary agreement that's not finalized. It goes to a lawyer. And so the lawyer now is giving legal advice, and the lawyer is saying, hey, wait a minute, you're giving everything away but the kitchen sink here. We need to change this. There's some things that I don't know that you should be agreeing with. Therefore, you should potentially either be going back to mediation, or I need to write some letters and try to see if we can change parts of this agreement before we actually draft it formally. So that's kind of where some of the negotiations happens, I think. But this is what I say to people as a mediator and as a lawyer. So when I'm mediating, I always say to people, it's really important to get legal advice before you come to mediation. And that legal advice, what it does, it sort of tells you what your bottom line ought to be. Not to say that your bottom line is going to, is the absolute, because you can go below your bottom line if you so choose. But the reality is that you are the one who's in the driver's seat, right? So you kind of need to be able to know what are some of the things that you can live with or you can live without. And your lawyer is going to tell you what the law is on certain things. So for example, you might be going to mediation and saying, I want to give up child support. I want him or her to not have any parenting time, and I'm going to give up child support for that. Well, we know as lawyers that the law doesn't support that, right? The law says child support is a legal obligation by parents, right? So, but we also know in mediation, if we were to look at this purely from a mediation standpoint, is that people are free to make agreements and do whatever it is they decide to do without having the interference of government bodies and various other people who might feel like they know better than we do in our own worlds. So we're free to come up with that agreement anyway. So now you go back to mediation, you say, okay, my lawyer says I can't actually give up child support, but I really want to do it. And I'm going to do it anyways. And now the mediator is saying, okay, great. You're coming into this with eyes wide open. There's no, there's no pretense. You're not sort of blind to all the things that could happen. Because what your lawyer should have also told you was, if you give up child support, it doesn't protect either you or the other person, because 5 years down the road, if you do decide to change your mind, you can bring an application in the court for child support. So the other person might be thinking, oh, wait a minute, yeah, I get away scot-free. I don't have to pay child support ever. But that's not really the truth, right? Something could happen later on. And this is why it's important to have legal advice before you go into mediation, and have an understanding of what it is that you're ready to give up, and what, what the rules are, the rules of engagement as you move forward. So I don't know if that answers your question, but I also wanted to add, like, for me, when I'm thinking about mediation, I think about an opportunity for people to actually be in the driver's seat, right? You get to design the agreement that works for you, the agreement that works for your family. And because not every family is going to be the same, it's very unique, right? And the exercise I wanted to do, Angela, I mentioned that there was an exercise that I wanted to do, just to sort of give people an idea of what happens in mediation versus what happens, in the courtroom. So imagine that this is your life. This is your story. Did I do this exercise last time? I don't think I did.
No,
Okay.
no.
Okay, so this is your life, right? This is the whole, you with your partner or your former partner, all of the things that you did together, and the craziness that happened in your world, and the wonderful things that happened in your world. Now you go to your lawyer and you're telling them all about this, and they can't really take in this much information. More often than not, they might take in this much, right? Because what's your consultation time? Maybe an hour, right? So you've got an hour with your lawyer, and they've been able to retain this much information. Maybe this much information is really what's relevant at the time, right? What's relevant for them in terms of the law. And now they're thinking, wait a minute, we need to sort of employ a different strategy when we go into court. And that strategy means that we can only tell the court about this much, right? So now we've strategized, this is how much information that's relevant for the court. The judge comes in for a case conference, settlement conference, I don't know what other kind of conference, and they can only have a conversation, maybe have only read this much about your life, right? And then by the time you get to trial, this is about how much your whole life comes down to. When you're in mediation, you get a chance to talk about the whole thing, right? In mediation, you get a chance to talk about, I know that you have this kind of parenting style. It's not working for a little person, for a little one. And I'm wondering whether or not we can talk about a different way of parenting, both you and I, just because we realize that this is the kind of parenting that may work for our child, given maybe their mental health, or perhaps they have some learning differences that require some different styles of parenting. And maybe together we can work on that. Maybe the other parent is not agreeable to that right now, but if you come back to the conversation 6 weeks from now, maybe they're starting to see something different, right? So there's a conversation that happens in mediation that doesn't typically happen when you're in the court process. And also, most of us, when we're in the court process, we're hiding behind our lawyers, right? Our lawyers are they're the ones with our voice. And let's face it, our lawyers, and we are lawyers, Rose and I are both lawyers, and we know that we can't tell a story as well as our clients do. We can't tell their stories as well as they can, right? And so for us, we are constantly trying to work on that process of how do we tell the best story that we can for our clients to ensure that they are heard well. And I think for good lawyers, I think that was one of the questions. How do you know when you have the right lawyer? Well, you know that you have the right lawyers when they are speaking your language, when they are able to tell the story the way that you would tell your story. And that's really hard to do, right? And not all lawyers can do that because we all come from different worlds and different perspectives, not necessarily just in culture, but also from our own backgrounds, right? Our own historical beginnings. And we all have different ways of looking at the world, and we tell the story from that perspective. So I don't know if that answers your question. I kind of went a little bit, I got a little derailed at times there, but I hope it helped.
I'd like to comment on the fact that Joanna is a mediator and she's a lawyer, but in mediation, she's not allowed to give legal advice. And so her recommendation of going to see a lawyer first before going into mediation is exceptionally good. In fact, I would recommend it very highly, because if you go in straight into mediation, you may agree to something that is totally not within your rights, what you're entitled to. And when you leave mediation, you go to a lawyer and the lawyer says, hey, you shouldn't have agreed to that, right? So it almost makes the mediation not as valuable as it should have been had they gone to a lawyer first. So definitely do that. As a segue, I also wanted to say it's not just court negotiation and mediation. There's also collaborative process. And I don't know if you really want to go into that, but it's another form of negotiating openly in a room with your lawyer, the other person's lawyer, and the two parties together. And there's an openness about that that's probably not even as open in mediation. I'm not speaking out of terms, I hope, Joanna, but because you're saying it right at the same time, but you also have your legal counsel to guide you and to speak to the other person as well. So I highly recommend that approach as well. And some people would like to have that. Others say, no, I'm going to try mediation. So it's another process that's available. And I just wanted to bring that up.
And sometimes sorry, Joanna, sometimes what I've seen is both can happen. All three can happen. You could go to mediation. Maybe it didn't work out. Maybe you felt a little bullied or something like that. Or like you didn't know what you were supposed to agree to or not, or you just didn't feel comfortable. It didn't work out. You didn't get an agreement. So then you move into the collaborative process and the lawyers are now present for these negotiations. And then when that fails, court, so I've seen all three happen sometimes in cases too.
And Angela, if I could add that, you can go to, first of all, you can go to mediation and narrow the issues, right? Perhaps you go to mediation and you resolve one or two issues, and then there's some things that are really big that you need to have your lawyer there with you. Sometimes people can bring their lawyers to mediation, but what I like about collaborative is the fact that there are other professionals involved as well. It's not just the lawyers, right? So there may be some financial professionals who are looking at all of the information and really coming up with a number that makes sense for both parties. And that person, their intention is to be neutral and to look at the numbers as it is, right? And they are able to ultimately establish a very objective description of what the party's financial situation is. And that information is then taken to the lawyer to then have some serious conversations around with their clients. As well, for those people who are having difficulties with the parenting time, maybe there's a parenting professional that can be involved that can then help the parties come up with a parenting plan that works. But again, doesn't involve the lawyer. And may also have a lower hourly rate. So it's a little more cost effective to deal with it in that way. And then, of course, it all comes back to the lawyer and the parties to sit in a room together and to come to some agreement in terms of how the final documents will be drafted based on all of that information that's coming at them from a neutral place. And the comment that Rose made, absolutely, you know, the mediator has to remain neutral. And so we can't give legal advice in a mediation. And sometimes people come to mediation thinking and expecting that that's what's going to happen. You know, the mediator is going to tell him or her how wrong they are about this particular issue. And I always have to say to people, that's not my role, right? My role is to remain neutral and to facilitate a conversation between people. And, you know, if you have a good mediator, if you're in front of a good mediator, that mediator is going to ensure that there isn't any bullying happening. So for example, in my particular case, when I'm in a situation where I feel like that's happening, I can end the mediation, right? So the mediator will end the mediation, or the mediator will not allow the person to agree to something that they know is not necessarily something that's going to be fair, or something that really is the agreement is happening because that person is not aware of certain things. So I will sometimes say to parties in the middle of a mediation, I think you need to get some legal advice before you agree to this particular piece, right? So if you're in the room with a good mediator, they're going to give you some direction, but it's never legal advice. It's just sort of trying to get you on track to make sure that you're not giving away everything but the kitchen sink. Because at the end of the day, it's exactly what Rose says. You know, you're going to go to your lawyer is going to give you legal advice, and the whole mediation agreement is completely now torn apart and is completely invalid. And now you've wasted your time and your money, and you're in a situation of starting all over again.
And I think there is, you know, there's a lot of value in settling as much as you can before you get to court, because when you look at that exercise you just did, it's very true. And it really resonates with me, because the reason I had so many court dates was because it was like one issue per court date, maybe two. Otherwise, it's a long motion, which could be 6 months out or whatever it may be now. I have no idea. But settling as much as you can, and then realizing, okay, what are the big things that need to change after you've settled? If conflict is still there, there's still harm or whatever is not working, you have to really sort of pick and choose your battles about what you're going to litigate, because it could go on forever. It could just, your litigation can just spiral on for years if you don't sort of determine those big issues to litigate. So yeah, settling ahead, you know, before going to court, settling as much as you can, because that big sheet of paper, if you can settle half of it, then your court battle will be a lot shorter. Okay, so let's move on to court, which I know you guys don't love, but let's talk about it, because how do you know when it's time to litigate? So we've gone through the whole settlement options, we've mediated, we've collaborated, done all these things, and there are still outstanding issues that need to be resolved. Your client is as reasonable as can be, as flexible as can be, is on the right path in terms of, you know, picking and choosing their battles, but the other party is perhaps high conflict, being unreasonable, wants something that your client just can't agree to. So what happens now? When do you determine that it's time? Is it a time frame? Is it the issues at hand? Like, how do we know?
So what I will preface all of this with is that you have to be careful that the lawyer doesn't keep trying to settle when it's obvious the other party is not going to. So in a sense, it's a time frame, but not necessarily. It's a matter of, you know, you don't say, okay, we have this file open for 2 months now and nothing has happened. That's not the time frame I'm talking about. It's the opposition you get. You figure out if it's unmoving. So you don't want to waste your client's money. So you know that the only way this is going to be resolved if the parties hear from a judge. And that's when you say, I don't think you have any choice but to litigate. And I don't say that very easily. So if there's a chance of negotiation, I will take that. But obviously, you don't want to waste your client's money either.
And I echo Rose's words for sure. It's being in the courtroom is not my most favorite moments in the world, honestly. But I seem to find myself there a lot because I am also a children's lawyer. So oftentimes when I'm in the courtroom, I'm there working on behalf of children. And what I see is that there is a need for courts, for judges to make decisions in situations where parties are at an impasse. So for me, when you feel like you're at that impasse, when you feel like there is, the other side is just not going to hear you, and maybe part of it too is that you're not hearing them, right? So it can go either way. And you just kind of need to hear from a judge. You need to hear from a judge's perspective how they would look at a certain thing. Now, if you have the right lawyer, that lawyer can tell you exactly how a judge is going to say this. Rose and I have spent a lot of time in the courtroom. So I think whenever I'm having conversations with people, I feel like I'm echoing the words of judges all the time. Here's what a judge is going to do, because judges don't really like to make decisions about people's lives. These are your personal lives, right? And they don't know it as well as you do. And so they're always very hopeful for parties to really come to an understanding and to come to conclusions on their own. But if you need to hear from them, or if the other side needs to hear from them, they're more than happy to kind of share the information and their insight. But ultimately, they're going to send you outside of the courtroom and say, hey, try and see what you can do to resolve this. And they might give their input as to how they think it should go, given what they have heard. Now, bearing in mind, they have only heard a portion of it, right? They've heard this much, and they're giving you direction on this much. So this is why anytime you can try and resolve things outside, do it, and do as much of it as you can, and take the hard things to the judges so that they can really give you insight on those hard things. So yeah, I would say anytime you're at an impasse, anytime, and try to move quickly through that process, because one of the things that I used to say to clients all the time, my most favorite thing on any file is closing it. And so, you kind of, I like to see my clients at the other side of a situation, sort of living their best life. And while you're in the situation, you're not living your best life. You are living a life that's really sort of circumvented by all kinds of trials and tribulations. I'm about to be visited by my cat, so just this is what happens when you're working from home, right? It is 9 o'clock at night, so he's expecting other things. So the reality is that I think that we need to be very cautious about sort of staying in a system that ultimately keeps you stuck. Right. So for me, I feel like you really should be moving through it as quickly as you can. And just know, if you can come to things from a neutral perspective, which is really hard when it's your situation, but to come to it from a neutral place and say, okay, I need to get from point A to point B because I need to be living my best life ever. And for me to get there, I need to work through these very bumpy spots. So how can we smooth these bumpy spots out? Do I need to go see a judge? Do I need to negotiate this? Do I need to get it into mediation? If there are family violence issues, well, when there's family violence issues, I will say that the courtroom is probably the best place, the safest place for most people, because most mediators would say, if there's been some kind of domestic violence, then we kind of need to screen that out. some mediators will say, because this is also a very controversial piece, some mediators will say that we can still mediate, but we can do things like shuttle mediation. So we can put people in different rooms and try to have a conversation between those two rooms. As long as people, as you said, Angela, isn't feeling bullied into a decision of any kind, right? My favorite words in the beginning of any mediation: you do not have to agree to anything in mediation, right? There is no pressure for any kind of an agreement. And I think that that was one of the questions someone asked, if I go to mediation and I don't settle, will that look bad on me? No, it won't, because the reality is the court understands and appreciates that, a conversation doesn't necessarily mean resolution, but it's a conversation, right? Wherever you can start the conversation, I strongly suggest it. Because especially if children are involved, you will be having these conversations for a very long time to come. Even when grandchildren comes into the picture, right? You're going to need to be, I've heard adult children say, I am not having 2 birthday parties for my kids like I had to have when I was a child, right? Because I'm not going to invite grandma one and then grandpa at a later party. It has to happen in the same party. So if you two don't agree, you're coming to the same party or don't come, right? So those conversations will happen forever. So it's time. You kind of need to start it as soon as possible.
So what happens, because we can have these goals. I mean, I had these goals of settling. I didn't want to go through 10 years of litigation. I don't think anybody does. However, some do. Some other parents, so the other side who may be high conflict, will see it as a new venue to abuse. A new venue to gain control, to win. They see it as a winner-loser situation. And really, it is. When you're in court, you're in a motion, you're in a trial, there's a winner, there's a loser. And here in Canada, in Ontario, that is shown through costs as well. So if you lose, you win your costs. The other parent loses hard, right? So it is this very adversarial process. And high conflict people thrive in that environment, right? So how do you get it to stop? This is not a question I sort of had on the table when we were prepping, but it just came, it came to mind. It's come through in the Q&A as well. How do you get control of the litigation when the other parent is just filing and delaying and not filing their financial statement and doing all these other things to delay and create more litigation? How do we handle that? There's obviously no settling with somebody like that. Just like saddle up, we just buckle up and say, all right, we're going for the ride. It's going to put us bankrupt, or is there some way to get a handle on that?
So I typically tell clients that, as much as you say there's a winner and there's a loser, I once had a judge say, the 2 parties are not going to be happy with whatever judgment I give. So I always tell my client, think about long-term. What do you want for your children? What do you want for yourself? And then pick your battles. What can you give on? What do you absolutely won't move on? And go forward with that kind of objective in mind. Like, don't argue about, the toilet brush holder or, a table or, bedroom set or whatever.
Bookshelves. That was one of my favorites.
Yeah. Mine was the toilet brush holder. So think about what's it going to cost you in litigation, legal fees, and is that going to be worth fighting for? Is it worth the price? Is it worth the emotional angst? Is it worth putting your children's lives in conflict? So think about it long term and make those decisions. It's not the lawyer's choice. In fact, stay away from any lawyer who prolongs litigation for you, right?
Yeah.
The idea is to move on.
And I echo Rose's words. I'm going to add, find your inner peace. Yeah. Because when you're going through something that difficult, the best piece of, and this is not going to be the best words, but the best ammunition that you have is to stay grounded, stay in your peace, find the things that grounds you, whether it be a walk in the park, to calm your nervous system, and I'm going to speak here now as a yogi, finding your breath. There are special yoga poses for gaining your grounding and your capacity to surrender into moments that needs surrendering. As Rose is saying, to be able to let go. What does that really mean for you? And how are you going to hold yourself either accountable or hold yourself in that space of calm, especially when you're in a courtroom? Judges notice everything. So when you are getting derailed, it's information for a judge in a courtroom, right? And when you are consistently in the defensive mode, that's information for a judge. So for you, the best place to be is to find your neutral ground and to really understand what it is that you're after in this space. My favorite thing to say to people is, on your deathbed, will this matter? And that's the piece for me, that holds me in just about everything I do, right? So when I am in a conversation with someone, if it's a serious, heated conversation, I have to ask myself, on my deathbed, will this information matter? Will this thing matter? And if it won't matter, then it doesn't matter now. Right? We get attached in ways that sometimes can be very damaging and a place of suffering for all of us. And so when I understand exactly what's going to matter on my deathbed, then I know what are the important things that I am going to, for lack of a better word at the moment, fight for. If I would use that language. I don't really like to use that language, but the thing that I am going to hold my ground for. Right? And the one thing you can hold your ground for is you, right? It's your own equilibrium, your own inner peace, your own sense of self-love. And I think this is the thing that we lose a lot when we are in litigation. There's lots of conversation, and I don't know that I'm going to do the quote justice, but Viktor Frankl spoke about, and I'll just do the gist of it, is ultimately the one human freedom that we all have is the ability to have our own perspective on things and to really be able to hold who we are and the way that we see the world and things that are happening to us, right? No one else can change that for us. And that's the one thing that I feel that as litigants, when we're going through, we lose ourselves in litigation. And that's, for me, the key and the thing that I'm always saying to parents or to people that we are representing: hold you. Because, and this is one of the things that I know Rose is really good when she's doing her coaching with clients who are going through the litigation process, right? Is holding that really special part of who you are, because that's the one thing no one can take from you. And the problem is that they are going to, that's the thing that typically will release you from whatever is going on in the litigation. Right? And it can speed up the process, or maybe the process isn't sped up at all, but it feels to you like it's not even happening, right? You're going through it smoothly. And yeah, I don't know, but it is the hardest thing to do. I know that it is. But that's the trick.
Yeah, I can speak from experience on that, because when I started the litigation, I was very worked up. I was very emotional and very primal. And everything was, it just felt out of control. I felt out of control. the situation was always out of control, but I was spiraling, right? And so it wasn't until I changed and I got control of that. I went to therapy. I got some, my lawyer was a great coach for me. She would tell me how to, navigate things, but most of it was in therapy and yoga and meditation and running and really sort of rebuilding my life separate from the battle. And one of the quotes I actually had posted on my computer at work, it was on a sticky note for 10 years. And it said, I get it from Wayne Dyer. I think it came from someone else originally. But it said, when we change the way we look at things, the things we look at change. And it's so true, because when I changed, I was able to live peacefully in the midst of crazy, right?
Mm-hmm.
And so it was, I rebuilt my whole life. I was able to have a home full of love. I was able to find love again and get married and have another child and build this peaceful space. There was still crazy going on around outside, but I felt more in control of it, and I was able to communicate better. I was able to put the major issues forward to the court in a way that, wasn't emotional, was just assertive. Perfect. This is what's happening. This is what we need fixed. We need a solution for this, that, or the other. And here's why. Instead of, he's crazy, he's this, he's that, he, and focusing on the other parent all the time, right? It was more of a focus on, what can I control? What can I do to speed up the process to the solution? And in a sense, I was mediating myself through the litigation. Awesome. So I wasn't in mediation, but I was working on myself and my reactions and my responses to things, because that was all I could control.
That's right.
You can't control the other parent. And so sometimes when you feel like, there were many times where I thought, okay, well, how am I going to stop this crazy litigation? I can't go on like this forever. And really, it was just one foot in front of the other with my own behavior, and just letting things play out. I think that's one of the biggest things when you're in a high conflict divorce, is just, there's a sense of, yes, you must have some strategy, but also just letting go a lot and controlling what you can, which is usually only yourself.
Yeah, I think both you and Joanna expressed it really well, is that you need to control your emotions. Once you put not react emotionally, once the emotions come out of it, things go so much smoother. So you're not reacting, you're not getting upset, you're thinking straight, you're thinking about what outcome you want and how to do it.
Yeah.
So I found the quote while you were both talking, and this is Viktor Frankl. This is what he says: everything can be taken from a person, he says a man, but one thing, the last of the human freedoms, is to choose one's attitude in any given set of circumstances, to choose one's own way. And I always find that very powerful, right? So my attitude, my sense of inner peace and grounding, the control that you spoke about, Angela, being in control of me, right? Finding the things that are going to bring me peace in the moment, no matter what the chaos. And sometimes I feel that is the one, that is the goal in every day, right? How do you find you amidst the chaos that happens around us every day, everywhere, not just in the litigation process, but in all parts of our lives? It's a great training ground for that. So,
yeah. And I think what's interesting too, is when you start to get into that work, you realize your whole life changes. So other toxic people you didn't realize were toxic leave, and fresh people come in with new energy that now match yours, where you are now. So I see that with my clients actually a lot, where they're like, oh, I just had this blow up with a friend of mine, and I realized that she's been doing that for 5 years. She's been treating me that way and I just see it now. And it's like, yeah, because you've changed. right? So when you change, you may see some conflict blow up a little bit with the people around you, but that's because they just don't fit anymore. They don't fit with where you're at.
Yeah.
We're getting really philosophical now. So I want to talk about, there's a question, what's the most cost-effective way to present evidence to my lawyer for trial, to show, whatever the issues may be in the case. And we were discussing this before everybody came on and decided that I was going to have to answer that one. So you guys can chime in after I get through it. What I found useful in my case when I was going through it was I used spreadsheets. Word documents for whatever I was sort of coming up to next. So if I knew, I had a running log, so I had a running spreadsheet of everything that was going on on a day-to-day basis that I felt, affected access, which is now called parenting time, or decision making. And I just kept track of those things. What was happening, date, description, and sort of where I put my evidence. And what I've done now is created a web-based system for people to use and do exactly that, so that everything is all in one place. And that can really, when we're talking about costs, can save lawyer fees. When you have everything all in one place, it's readily accessible, and either your lawyer can pull it out quickly themselves, or you can pull it out, find everything quickly, and send it off to your lawyer in one foul swoop, instead of 16 different emails where they have to open it, charge you for that, open another one, charge you for that, print things off, charge you for that. And so if they have everything all in, I tried to consolidate as much stuff into one email as I could so that they would have everything. So the web-based system that I have, I know many people here are already using it, but that I have found has helped clients cut down on their legal fees. And it also categorizes things in patterns. So if you're looking for that medical report or that police report or that text from your ex about whatever it was, you can quickly find that stuff and send it off. So that's what I think is useful. How do you guys like receiving information from your parents? Not your parents, your clients.
Ideally, it would be as organized as your software does it. And very important, you are so right when you say emails one at a time, every day, several times, that's going to cost you money. So if you can organize it the way you have it on your system and provide it to the lawyer, it certainly helps their job and makes it faster and easier. Obviously, as we spoke about before, the lawyer does have to tease out more information, and the lawyer will know, okay, this doesn't sound quite right, to explain to me what exactly happened. But at least it's there, it's captured, and the client doesn't have to go by memory. So yeah, your system sounds like it would be extremely helpful.
And I agree. I think when we were having this conversation as well, that ability to tease the information out. But your example, Angela, about sending email after email after email, you also are trusting that your lawyer is terribly organized. Most of us are. But there are some of us that are not. And so there may be emails going missing, or perhaps it doesn't make it into the information that you want you want to have before the court. So it's really important. Maybe your lawyer's asking you for that information over and over again as well, right? So when it's in one place, it makes it so much easier. So I agree. Absolutely.
I always felt like if I did as much work as possible, that it would save me money. So as soon as I saw the process of writing an affidavit and presenting evidence in court, my brain kind of works in patterns. And so I built the pattern in my brain of, okay, this is what we need to do. And so if I took some of that load off my lawyer, of course, she still, did her thing. But if I could give it to her in an organized way, there was a lot less time spent, for her having to sit there and put everything in its place. She could just cut and paste and then flare it, make it pretty, make it legal. And, also when you're meeting with professionals too, like my custody evaluator, same thing. I went in really organized. I could have just handed over a pile of stuff and talked in a timeline, but I didn't. I went in and I talked in terms of patterns that I was seeing and then the timeline. So it's like, we've got these issues and it all started here and it's now escalated to this point. And we've got this issue and it's now escalated to this point. So that they could see the pattern and not have to do that work themselves. So it is like cutting to the chase, right? Taking away half of their load so that they can focus on like the analyzing part and the judgment part and figuring out, what they're going to do with all this information. I don't know. I found that to be helpful in my case.
It would be. It sounds like it. Yeah.
Okay. Can we talk about the children's best interests? Because that term is everywhere. When you're talking about court, you're talking about family law, what are the best interests of the children? People are sick of hearing it. Maybe they're not, but I don't really think people understand what that means. So can you guys break it down?
I'll let Joanna take the lead on this one.
Thank you, Rose. This is well, it's a big question. It's a very loaded question. Best interest, it's really a court's prerogative to determine a child's best interest. It's not something, you or I or any other organization or institution has the capacity to do that. A judge determines what a child's best interest will be. And there are lots of factors that goes into a child's best interest, and the legislation itself does point to, things like you may have heard this terminology, the friendly parent rule, or, ensuring that children have maximum contact with another parent. Like there are all kinds of things that a judge has to take into consideration when they're considering a child's best interest. Some people, there's a lot of controversy around it as well, right? This whole notion about it's unfair, it can be dangerous in situations where there's been domestic violence. So there's a lot of that conversation. Some will say that, it promotes a healthy relationship with children and your co-parent. It may be something that it supports a schedule that allows for children to enjoy both families and to have that connection with both families, both mom's family and dad's family. So the court ultimately has to balance that piece along with protection of children. And at the end of the day, it comes down to the evidence that's presented to the court, right? In terms of what necessarily would be in this particular child's best interest. What's the evidence before the court that ultimately says that this is the right decision? And sometimes even the court gets it wrong, so it's not there's no hard and fast rule, because at the end of the day, and like when I saw that question, I thought, wow, we need to remember that this is a human system. The court process is a human system. Judges are evaluating evidence. And they are human as well, as the evidence is coming to them as coming from a human perspective. And so they're trying their best to try and determine what is in this child's best interest based on all of this information that's coming at them, again from a human perspective, and again from that is highly subjective, right? So there's no objectivity really when we're talking about a child's best interest, except for when it's really blatant that there's been some child protection issues, right? But then the court at that point will rely on child protection agencies to step in. So independent agencies to step in and say, hey, there's been some protection issues here, and therefore it won't be in a child's best interest to really make a decision if there's been protection issues, right? So I've had, clients who said to me, and this is when I used to do advice counsel, where they would say, he or she is very abusive. And then I would have to ask the question, right? As you talked about, Angela, having the court, having the police reports to demonstrate that there's been some serious issues, and really what does the report say about those issues, right? Were the children involved in that incident? Were they present when the incident happened? Is this parent, someone who is violent in relation to partners, but not necessarily in relation to the children, right? What are the pieces that we have to look at here? And the court rely heavily on independent evidence, right? They're going to rely on police reports. They're going to rely on child protection agencies. So I would always have to say to people, do you have a police report? Has the CAS been called? Is the CAS feeling that there's some protection issues here? And will they put their money where their mouth is, right? Will they ultimately write a letter saying that there's been an issue here? Otherwise, it's as we said in the beginning of all of this, it's like he said, she said, right? And unless there's actual independent evidence, the court's going to struggle with that. And this is one of the reasons why, children's lawyers are then appointed. And I can tell you as a children's lawyer, sometimes it's difficult even for me, right? A child says, and children's lawyer, typically, we have to bring the children's views and preferences to the table. So a child may say to me, I want to remain in this particular parent's care, but that parent may be a parent that's being abusive. I have many cases, even as we speak now, where this is occurring, right? And the CAS, the Children's Aid Society, has not ultimately stepped in because there isn't enough information for them to say, you know what, there are protection issues here, or maybe they know there are protection issues, but it's not at the level that they need to interfere. Right? It's like the least intrusive method is what the Child Protection Agency has to employ. So it's a very complex, I don't know, everything I'm saying to you, I'm hoping you're seeing by this point that it's a very complex assessment. It's one that the court needs to make. I have to say to people, usually when I'm as a children's lawyer and I'm talking to parents, my job is not to determine best interest. My job is to bring the children's views and preferences to the court. The Children's Aid Society's job is to determine whether or not there are protection issues. And then the court's job is to determine whether or not there is a best interest issue at hand, right? So it's very complex, and it's a case by case sort of assessment, and it's done by the court, and it's done with a lot of different factors in place, right? If you don't have the domestic violence pieces, then the court is looking in a very big way at ensuring that children have maximum contact with parents, right? Not necessarily a shared, it's not like the default is a shared parenting arrangement, but certainly how can we increase the contact with this child or children with the other parent? And even if there's no physical contact, can there be virtual contact? Can there be other ways of ensuring that this child knows that the other parent loves them? Because we know that when children, I mean, the research shows, and I'm not speaking as a researcher here, but definitely from the information that we see, is that children do better when they're parents who are communicating and they are on the same page when they're parenting. They are very respectful to each other when they are parenting, even when they're in different households, right? Children will have better lives. Like I always say to parents when I'm doing the parenting program, the way that we started out always is I get parents to list all the beautiful things that they want for their children. Tell me all the great things you want to see for them. And then I have to say to them, your behavior and the way in which you are communicating and your inability to negotiate effectively and to use tools that are going to employ respectfulness and kindness and compassion is going to determine whether or not your children achieve some of those goals and dreams, right? They may achieve them, but they may not be a whole person. There's another exercise that I do with parents. I give them a doll, and not a real doll, but a paper doll, and I say, tear off a piece of the doll every time I ask the question, right? So every time you roll your eyes when the other parent calls the house, every time you say, things like, your father's on the phone, or something that's really, your tone of voice is really unfriendly whenever the other parent is showing up. Tear a piece of the doll. Now, by the time I'm finished, oftentimes parents only have like a little tiny piece of the doll left. And I say, this is the person that we're sending out into the world as adults. And I know, and some of us are going into the world as this very same kind of an adult too, right? So the key is, and now this is not to say that you're half of a person or your children are half of a person, but the idea is that we struggle with children experience a great deal of trauma when their parents are doing these kinds of things in their separation. So we have to find ways to get them back on track. So this is why the court, they're looking at all of the pieces. They have to sort of make the best decision they can in regards to children's best interest, because they realize that, when children are in these very difficult situations, it's really hard for them to fulfill their potential. So the goal is to focus on children. Now, there's all kinds of controversy around that about, should we focus on parents' needs versus children's needs, and how does that really work? And it's a tricky one. I don't know that there's a real answer to any of that, but I hope I did the best job I could on that one. I don't know, Rose, if you have anything to add.
The guidelines are very broad, when you say the emotional and well-being of the child. How do you measure that, right? They talk about the relationships within the family. It may well be that if you're talking about the best interests of a child to remain with mom as opposed to dad, you may be looking at, okay, he has other siblings that may not be, the same biological father, and you want to maintain that contact. The child sees that as his whole family. So it would be wrong to uproot that child and place him with dad. We talk about, who's been caring for the child all along. What is a child accustomed to? The school he goes to, the friends he has in the area. And all those are just little chunks of what goes into what makes it the best interest of the child. So Joanna is right. It's very complex. And sometimes one parent will have different views of what's in the best interest of the child. And so ultimately, it boils down to the judge saying, I think, given all the evidence, that it's in the best interest of the child to be in the care of mom or dad, as the case may be. So there's no precise answer, is the rule. And I think if you look at a happy child, if the child is happy where he is and being taken care of, his needs are met, that probably is in the best interest of the child.
Mm-hmm. Absolutely. And that whole piece that Rose that you mentioned about, it can be different parents have different perspectives. And just to give you a very, this may be an example that seems completely frivolous, but here it is. One parent once said to me, I don't think that the other parent is doing as well and is taking care of the children's best interest, because what he does cooking with them, but he doesn't teach them about measurement while he's cooking. And therefore, they're not in a good learning environment, and they ought to be learning in everything that they're doing. So that was one parent's perspective of what would be in their children's best interest. Dad had a different way of parenting. And so this is another thing that the court has to be very cognizant of, right? Is that parents sometimes can fall into the trying to parent in the other parent's household, right? Demanding and dictating what the other parent does as a parent, and because of their perception of what it means to be, good for children, and what's the best plan for a child, right? So we all have different perspectives of what good parenting is and what bad parenting is. One of the things that I always say is that children need one loving, caring parent. And the other parent, who may or may not be that way, is a wonderful opportunity for them to see difference, right? It's an opportunity to prepare them for the world, to show that not everybody is going to be like this one parent, and teach them tools and strategies on how to manage when they're in those situations. Now, of course, that's all depending on the child's age and development and capacity and ability, right? Because there may be some children with some issues that we cannot put them in situations that are problematic in that way. So it's really yeah, exactly what Rose said. And it's a question that comes up a lot, that I sometimes struggle with as well. So
Okay, I have a thank you. That is a loaded question, I know. And it's like you said, complex, but it's so case specific as well. So it's really difficult to answer. I have a couple of questions from people here, and I think you may or may not be able to answer them, whether they're legal advice or not. I will leave that up to you. You are the professionals here. One question is, how bad does it look to agree in mediation and then disagree to everything at the case conference? This person is heading into trial due to the child's father suddenly changing his mind on everything that they agreed on in mediation, it sounds like. Will this show the judge that he's trying to control and drain the bank account?
I think that was sort of touched on earlier, is that in mediation, you can agree, but you leave there, you may have had a change of mind, or you've gotten independent legal advice. And so to change your mind, it's your right. Obviously, if he has good reasons for changing his mind, that would be support in why he changed his mind. So a judge wouldn't necessarily say this person is controlling or whatever. It just has to be backed up by some kind of reasoning why the change took place. Maybe he didn't understand it, or maybe he had come to the decision too quickly to agree. So I don't think too much should be read into that. Joanna?
I would agree. I would agree with you, Rose. Mediation is a voluntary process. And anything that happens, or any negotiations or settlement in mediation, really stays in mediation unless, of course, it's then drafted in a formal agreement. So the court typically is not as interested in the information if it hasn't been drafted in a formal agreement and executed in that agreement. So the court will probably be more disenchanted if people try to say this was already decided in mediation, this was already agreed in mediation, and now they're disagreeing. Because the court, technically speaking, the court cannot really consider what was agreed upon in mediation unless it is finalized as an executed agreement. So, and exactly what Rose is saying, right? People change their minds, which is why I always say, as a mediator, please get independent legal advice so that when you come to the mediation table, you're coming informed, and you're ready to actually be prepared to come to some understanding and an agreement in mediation. And also to be able to go back to your lawyer, see if you already know what it is that your bottom line is. It's easier for you to go back to your lawyer and say, you know what, and I know that we're talking about the other person here, but is to go back to your lawyer and say, listen, yeah, I do know that is what the law says, but I'm comfortable with this particular process. I'm comfortable with this agreement. I understand what I'm giving up. I understand what the consequences are, but I still want to agree with it. And then that's an agreement between you and your lawyer. You know, you and your lawyer can sign an acknowledgement, or you sign an acknowledgement that your lawyer's given you proper legal advice and you've chosen to go against it, and it's all good. Now you're ready to sign the agreement, right? So that's if the other person on the other side really felt that way. But it sounds like, you know, maybe as you the question suggests that he's attempting to drain the bank account. I don't know that the judge is going to go there right away. Like, I don't know that that's going to be the conclusion they will come to necessarily. And I just want to point out that again is not legal advice. What Rose and I are saying is not legal advice. We're just saying this from what we have seen, right? This is the information that we're sharing based on our experience in the courtroom and hearing from judges and how they look at things.
Yeah, thank you for that. And I think at case conferences and settlement conferences, it's important to note that those are opportunities to settle as well. And if a settlement isn't reached, then you're moving on to the next step, which is either a motion or a trial, right? Is that
yes. Yeah, absolutely. And it's the same way, you know, like things that happen in settlement conversations, in case conferences and settlement conferences, doesn't show up in a trial, right? That's not information relevant for a trial judge. So just it's the same idea, right? The trial judge doesn't want to hear about what you've settled in what you've discussed in a settlement conference and what you promised in a settlement conference, and now you're giving it up, right? So these are some of the things that's very important to bear in mind, very similarly in mediation as well.
So we're a little bit over time, but I do have one more question here that I want to put out there, because I think it's a really good mindset discussion that we can have. The question here is, the father has consistently tried to character bash me with our daughter's doctor, school, all the professionals she has to work with as a high needs 3-year-old with medical needs. What do I do? I'm trying to be focused on my daughter, but it's extremely uncomfortable when I've heard that he's given damaging misinformation. So this happens a lot in high conflict. We have the high conflict parent going into the school, going into the doctor's offices, creating, false narratives and giving, the child's fine in my care, but not fine in mom's care. So mom's the problem, right? And it can be that, it can be multiple things happening in the different arenas. I know for me, that was something I adapted to it no doubt causes harm for the children. No doubt. I mean, the school is their place of, peace and quiet. It should be their safe place to just learn. The doctor's office is the place that takes care of their health. Their therapy, should be their safe space. And oftentimes these places become new battlegrounds in high conflict. And I know for me, it was very important to just remain calm and just show these professionals that I could walk in there, give them the facts, say, this is what's happening with the child, completely focus on the child. And when conflict brewed, I had to make decisions sometimes. Was I going to remove myself from that situation? Maybe I had to reschedule an appointment. Maybe I had to get my lawyer involved. For me, it was a mindset thing. Is there other ways of dealing with this, or is it strictly like we need to sort of figure out how to control it ourselves? Are there any tips, tricks that you guys have for dealing with somebody like that?
I think from a practical standpoint, if you're taking your child to a doctor and the doctor is saying, the dad has said, you're doing this, or refusing to give her the medication or whatever, it's your mindset of saying, this is what I'm doing. Like you said, you explain yourself, what is actually happening, what you have done, what you're responsible for. And it's then up to that professional to make the judgment of, am I getting the truth from dad or mom? What do I have to do about it? But if it keeps going on to such a stage where it's concerning, then get your lawyer involved. Your lawyer can write a letter to the other party or in court documents saying, this has to stop. He's not supposed to malign you or speak ill of you, and not to bring the child into conflict if it affects the child. The same with the school is you should have access also to the school and give your side of the story. Then you can simply sit down with them and say, I realize it's, a lot of conflict going on, but I assure you, I have the best interest of my child, and I would never do anything that would put the child at risk or harm the child or be detrimental to the child. So if you just establish that relationship with the care providers, and as you say, control your own mindset, realizing that this person is trying to gain an advantage in some, misconceived way, but you do what you do as long as you know it's right. And never mind about the other person. It's only relevant if, like in court documents, you have to indicate that this is happening. That's my opinion. I don't know what Joanna has to add to that.
Great. It's a great opinion, Rose. What I would add is never underestimate the professionals in your world. Professionals have seen this stuff all the time. Most professionals who are professionals, right? There's some people who are not. And I will be the first to say I've encountered, teachers and professionals, other medical professionals who are not necessarily as professional. But that's okay because they have supervisors and managers who will be professional, and they have rules and various policies that they have to follow as well. So I, as a children's lawyer, I get to go into schools quite often and view children's OSRs and speak to principals and sometimes teachers. And they usually know who the parents are in terms of calmness, and the ones that are more agreeable, the ones that they can work effectively with. So if you are, as Angela, you're saying, you changed your mindset, you were able to sort of approach the situation from a place of calmness and knowing really who you are and what you're about, that comes across, right? Professionals can see that because we've been dealing, and I speak about it even as a lawyer, right? We've been dealing with so many different personalities that we can pick up very quickly and easily when someone is a little off, right? I mean, I've had situations where parents will say to me as a children's lawyer, oh yeah, when you speak to the other parent, they're so charming. They're going to charm you and they're going to make you believe all of these things, but they're the worst person on the planet. And then I have to say, you need to trust that I am able to make the right assessments and to do the right things because, I've had a lot of experience. You won't be the first parent that I've encountered. You won't be the first family that I've encountered that's been in conflict. And you won't be the last, And so trust the professionals. Don't underestimate their capacity to see the forest for the trees and to be able to see that, there's something a little off. The other thing I want to say is children are the best barometers. Sometimes a parent might say, oh yeah, this parent does everything wrong. But then you get to see, and this is one of the reasons why as a children's lawyer, I like to see parents bring children to me because I get to see how children are interacting with that parent. I get to see the sense of release and relievedness that they have when that parent walks in the door with them, right? And children are incredible with that. And, you know, I can see when a child is feeling a little uncomfortable and stiff in a situation, right? Even teenagers, they're really, you would think, you know, sometimes parents will say, oh, my child will never speak to you. They don't speak to strangers. And they walk in the door and, you know, they're like completely off the wall and telling me everything, but, you know, about their family and all those great stories that maybe they shouldn't tell me. I never have to ask children about the difficult moments. They tell me about it naturally. And you know, it's one of those things that as parents, we try to control every element. And it's in attempting to control every element that we start to become frazzled and derailed. And then those professionals are saying, uh-oh, both of these parents are off the mark, right? So you want to remain calm, you want to stay grounded, all the things that we mentioned earlier, right? You want to make sure that you're presenting your best self every time. I think I heard once, you know, be the kind of person that whenever someone says something negative about you, no one can believe them,
Yes.
right? Because you've always done the right thing. You've always stayed the course. You're not bad mouthing the other parent with the teachers, but then the other parent is doing it, right? They know very quickly. Wait a minute, every time this person comes in, they have these things to say. But then the other parent comes in and the other parent says nothing but great things about them, right? This happens in mediation all the time. You know, we ask, what's your most favorite thing about the other parent? And one parent might say, oh, you know, they're the best father and really good father. And then the other parent will say, I can't find anything good to say about that person. That's when I know where the problem lies, right? The problem lies with the person who can't see the forest for the trees, right? Who is finding fault in the other parent consistently and cannot really find something good to say, right? So don't underestimate that power. It's very powerful.
Yeah, and I will say that that is a difficult question for many people, you know, because they are caught up in my world anyway, in high conflict. And I ask them the same question, you know, when we do work on, you know, preparing and mindset and stuff, I often ask, you know, what is the other parent doing well? What makes them a great parent? And some of them will give me a snippy answer back and they'll say, oh, he's really reliable in terms of being an asshole. And I, you know, oh my God, this wasn't a joke question. It was serious. So that's where I know there's some, you know,
Some
things
work.
need to be worked on. But I can't fault them for that because you know, I've been through that anger phase. And when you can step out of it is where true freedom is. That's where you feel strong. That's where you feel confident. And you may be in fear still. You may have things happen where, you know, you're still nervous and anxious. And of course, court is very scary, but you know, you've made the right decisions along the way. You're in the right mindset. The professionals see you for who you truly are. You're showing up authentically to every venue you enter. And yeah, nobody's going to believe all the smear campaign that the other parent is doing on you. And I will say that, you know, when you, Joanna, said that trust that the professionals will get it and see that can be very difficult to do too. And I've felt that throughout my case. You know, there were times where every time a new, you know, CAS worker, for anybody who's here in the States, that's the Children's Services here. Every time a new CAS worker came in, it was like, oh, great. Now they have to see it, right? Now they have to see it for themselves. And it's like a new person comes in and it might take them a minute. It might take them weeks, months to see what is actually going on here, because yes, there is an element of charm on the other side. There is an element of hiding the truth and being able to do that for a period of time. So it did take professionals sometimes weeks, months, years to really see what was going on. But I will tell you that once they get it, you know? So as long as you are consistent in how you show up to these professionals and how you show up everywhere in your life. For me, it wasn't just with my court battle. It was, You're going to get Angela, the same Angela here that you're going to get out there at the grocery store, at the soccer game, at the pool, at the parent-teacher meeting, on the phone with the, you know, the car sale, the duct cleaner guy, like whoever I came in front of, I was me. And I was calm, I was focused. Not to say I didn't get emotional. I did get emotional, but you can get emotional and show people that you can control that emotion, that this is a very emotional time, but I'm able to still focus on the things that are important here. So, you know.
In fact, it's the best evidence, right? When there's difficulty and you are able to manage that, right? Because that's when you're demonstrating you're not going to be over the top, right? You're not going to be the person that's going to become defensive and reactive and counterattacking, right? Those are the pieces that we talk about a lot in the parenting program. You know, try not to be in the defensive, you know, be in the place of the best possible outcome. What is the best possible outcome in this particular situation, right? And if you're focused on that, then you don't have to worry about what happens in the outcome. And I agree with you, Angela. I mean, not all, and I've heard this complaint a lot from parents. You know, the CAS worker not understanding and appreciating where they're coming from, and you know, as a result, they've taken the other parent's side, and it's become very difficult. And you know, we're not all perfect. This is what I remind people. It's a human system, right? And this is why, you know, some workers, all workers have children's aid worker, they have supervisors and managers. Not to say that you're going to those people, but they're not alone making those decisions, right? So if you can stay grounded and you can stay calm and you can stay neutral and you can stay, you know, in yourself and the strength of who you are, more often than not, that information will make it to the top, and those decisions are being made at the top to help you as you move forward. And consistency is one of the best ways to do that, right? Staying consistent in who you are. Eventually, people will see it. They will have no choice, right?
Yeah, agreed. And sometimes they don't, to be honest, sometimes they don't get it. And sometimes there are, you know, there are problems everywhere, but yeah, I see it working more often than not where people get it. If you are in the right, yeah.
But bearing in mind, theirs aren't the only voice, right? So the children's aid worker is not the only person in your world, right? You've got other people in your world, like the school, like the principal, like, you know, other professionals that may be in the child or children's lives that can speak to your consistency as well, right? So if the CAS worker doesn't get it, it doesn't mean that that's the last voice that's going to be heard, right? Remembering that if this is in court, a judge is looking at all the pieces. Yeah. Right. We just did a trial where the judge basically said, hey, you know, there's it was a children's lawyer, but it was a clinical assist who drafted a report based on, you know, what their perception was and made recommendations to the court. And the court found the holes in that report. And this is a social worker that's looking at the family from a, you know, psychosocial perspective and is giving evidence. And the court says, no, I see the holes. There are definitely gaps in the work that this person did. And because we've also seen this other side and all of these other people, and their evidence is very credible and consistent, right? So just know that there's not just one side of the story, right? There's so many voices in that story. And this is part of when you're collecting the right evidence to get it before the court is really important.
And also why it's important to be the same person in every setting and be authentic, because you don't want to show up with holes somewhere.
Mm-hmm.
So
that's right.
Well, I think we've gone way over time. And I want to thank you both for being here tonight. I know it's late and you're probably very tired because you probably had a long day, but I appreciate you. And thank you so much. We will figure out the next, maybe in the new year, another chat. We'll figure out what the theme will be then. If you guys are up for it, of course.
Absolutely. Rose said, sure.
All right.
And thank you for having us. You know, it's always great. It's nice to have these conversations. You know, we don't get to have it all the time, so it's nice to have them.
Yeah, I think it's very helpful for people to hear your perspective and understand, you know, without having to spend hundreds of dollars having this hour and a half discussion with their lawyer. So just getting this mindset work and this understanding of the system that they're in is super helpful. So thank you again, guys. Thank you to everybody here. I hope you all found it informative, and I will email out the recording to all of you so that you have it to watch again in your free time if you missed any part of it. And that's all. That's it.
Okay. Thank you very much. Thanks for being here.
No problem. Thank you, guys. Have a good night.
Bye.
Good night, Angela. Good night, Rose.
Good night.